Divorce, by its very nature, is a profound emotional upheaval, but it is equally a stark legal and, of course, a financial reality.
Absolutely.
Today, we are undertaking a critical deep dive into spousal maintenance, focusing specifically on the legal architecture governing this in South Africa.
That would be under the Divorce Act number 70 of 1979.
Exactly. The mission for you, our listener, is not just to catalog the factors, but to genuinely understand the precise criteria, the judicial balancing act that determines if maintenance is awarded and for how long.
This knowledge is fundamental. It's about protecting one's financial future after the dissolution of a marriage.
So where do we begin? What's the legal starting point?
Well, it is essential to establish the foundational ground immediately. The Divorce Act provides two very distinct pathways for addressing spousal maintenance.
Two pathways.
The first, governed by Section 7.1, allows the parties themselves to reach a consensus. They negotiate and formalize their financial arrangement in a written document.
The settlement agreement, often called a consent paper.
A consent paper, precisely. This route gives the parties control over their own outcomes.
But I imagine agreement often proves elusive, especially when the financial stakes are so high. What happens then? What happens when the court must step in?
And that is where the power of Section 7.2 comes into play. If no agreement can be reached, this section grants the court a sweeping discretion to determine what it deems a just order.
So the court decides for them.
It does, and the provision recognizes the inherent uniqueness of every marital breakdown. The crucial insight here, and this is often misunderstood, is that maintenance is never an automatic right.
It's not guaranteed.
Not at all. It is entirely contingent upon the court's comprehensive and careful evaluation of specific compelling factors. So we really must unpack the criteria the court uses to justify its intervention.
Okay, let's do that. Let's unpack this discretionary framework, because this is where the complexity truly lies. The court faces a challenging task here.
It does.
It has to resolve the conflict between two opposing demands: the historical duty of support versus the modern expectation of self-sufficiency.
The clean break principle, as it's often called.
Exactly.
Yeah.
Where does the court begin its assessment?
It begins with the financial mechanics. So we look at factors 1 and 2, what the Act calls means and earning capacity.
Means. That sounds quite broad.
It is incredibly broad. It includes every single financial resource available to both parties. We're talking about salaries, passive income from rental properties, dividends from investments, and the value of any capital asset.
Everything.
Everything. And what's particularly intricate is determining what we call prospective means.
Looking into the future.
Yes. The court has to look ahead. For example, if a large pension fund is being divided or a business must be sold, the court has to project what financial resources each spouse will have after that division of assets is finalized.
Because that division directly impacts their need for maintenance or their ability to pay it.
Precisely. It's not just a snapshot of today, but a projection of financial viability for tomorrow.
That makes sense. Now, what about earning capacity? How does the court assess potential income, especially when a spouse might claim they can't find suitable employment?
Well, earning capacity is where that clean break philosophy is most visible. The courts strongly favor independence. A spouse is generally expected to use any available skills or qualifications to become self-supporting.
So if a younger, educated spouse has simply chosen not to work,
the court will likely impute a potential income to them, which would reduce or even eliminate the need for support.
But is it realistic to expect a spouse, say in their mid-50s, who dedicated 30 years to raising a family, often as part of a shared marital agreement, to suddenly acquire an earning capacity they deliberately gave up decades ago?
And that is the core conflict the court grapples with. It highlights why context is everything. When a court sees a spouse whose earning capacity is severely diminished because of the marriage's duration and their role within it.
Perhaps they lack marketable skills or they're nearing retirement.
Exactly. In those cases, the expectation of a rapid clean break is dramatically tempered. The court then recognizes that maintenance may be necessary, sometimes indefinitely, to compensate for that lost career path.
So understanding capacity leads us logically to needs. If we know what they can earn, how does the court determine how much they actually need? This would be factors 3 and 4, defining needs and existing obligations.
This is where a crucial legal distinction must be made. Maintenance is fundamentally a mechanism for needs satisfaction. It is not a tool for wealth redistribution.
So the court scrutinizes every claimed expense.
Scrutinizes it carefully. A genuine need covers reasonable day-to-day living costs, housing, transport, food, necessary insurance, utilities.
What happens if a spouse tries to claim maintenance to cover, say, maintaining a fleet of luxury cars or funding extensive international travel, things that weren't really part of the sustainable day-to-day life?
Those are likely to be rejected. The court must filter out what we might call aspirational luxury versus genuine necessity. The benchmark is the reasonable standard of living enjoyed during the marriage.
Ah, so it's pegged to their shared history.
It is. If the couple live modestly, the maintenance order will reflect that modesty, regardless of how wealthy the paying spouse remains. And of course, existing obligations, bond payments, contractual debts, the need to care for children or elderly parents are all factored in.
This level of scrutiny brings us to factors 5 and 6, the roles played by the duration of the marriage and the age of the parties. How do these contextual elements influence the court's assessment?
Age and duration are powerful amplifiers of the other factors. Consider a very short marriage, perhaps less than 2 years, between two young professionals.
The financial ties would be simple to sever.
Very simple. Neither spouse has suffered a significant loss of earning potential. In such cases, the court is highly likely to impose a very brief, fixed-term maintenance order, if any at all.
But with a longer marriage, it's a different story.
A completely different story. The longer the marriage, the greater the legal acknowledgement of the mutual dependence and the potential career sacrifice made by one party. In a marriage of 15 years or more, where one spouse left the job market, the court understands their capacity to reenter is severely compromised.
And their age would play a huge role, too.
A huge role. Advanced age, say over 60, can render the clean break almost impossible, necessitating ongoing or what we call rehabilitative maintenance to cover training or a transition period.
So age and duration essentially define the level of financial disruption.
Yeah.
That leads us directly into factor 7, which is the standard of living itself.
Absolutely. The standard of living during the marriage is crucial. Now, the court cannot perfectly replicate the joint financial position. There are now 2 households to run, not 1. But it aims to prevent an undue diminishment for the receiving spouse.
So a drastic drop in lifestyle is something the court tries to avoid.
It does. The objective is to achieve a financial equilibrium, where feasible. If the family enjoyed a high standard of living, the court will strive, within the payer's means, to ensure the recipient can maintain a commensurate quality of life.
And finally, we have to address the complex and often controversial factor 8, the role of conduct, or fault. Fault is no longer central to divorce in South Africa, but how does it still find its way into the maintenance decision?
This point requires careful clarification. You're right, fault is no longer a prerequisite for granting the divorce itself. However, under Section 7.2, the court may still consider misconduct.
But only in specific circumstances.
Only if that conduct relates directly to the financial situation of the parties or the reasons for the breakdown. The court is not there to punish emotional failures.
So infidelity on its own wouldn't be a major factor.
Unlikely to be. Conduct only really becomes a major factor if the misconduct caused the financial decline of the marriage. For instance, if one spouse compulsively gambled away substantial assets.
Or perhaps abandoned a high-paying job just to avoid paying maintenance.
Exactly. That conduct is relevant because it directly impacts the means and the needs assessment. It is not about personal failings. It is about financial detriment.
Connecting all this together, it really reinforces that spousal maintenance under Section 7.2 is not a simple calculation. It is a nuanced, holistic legal assessment.
Indeed. The methodology is designed to balance all these competing demands, the needs, the capacities, the duration, the age, the lifestyle, to achieve a pragmatic and genuinely just resolution. The court attempts to ensure that neither party is unjustly enriched nor unfairly impoverished.
Which means every case is unique.
Every single case must be assessed strictly on its own specific facts. An order in one case is rarely, if ever, transferable to another.
And here's where it gets really interesting and requires some reflection from all of us. Given the court's strong emphasis on that clean break principle, to what extent should a spouse who intentionally forewent a career, perhaps to raise children as part of a mutual agreement, be expected to immediately adapt their lifestyle and their economic expectations following a divorce? That balancing act between compensating for lost opportunity and driving personal independence, that remains the central challenge.
It certainly does, for both the courts and the individuals involved.
This deep dive has served as your shortcut to being comprehensively informed on the intricacies of spousal maintenance under South African law.
And we must conclude with a necessary and crucial reminder. The contents of this discussion are strictly for informational purposes only. They do not constitute legal advice. For any clarity regarding your specific circumstances, consultation with a qualified legal attorney is absolutely required.